Changing a child's last name without father's consent. When and how?
Hello everyone. Today we're going to delve into a fascinating and sensitive area of family law. Specifically, we're discussing the circumstances under which a court would allow a parent to change their child's last name without the father's consent. Let's begin by understanding the underlying principles that govern this issue.
What is the general rule?
As a general rule, both parents need to consent to change a child's last name. The rationale behind this is to uphold the rights of both parents and the best interests of the child. It promotes a sense of identity and connection with both parents. However, there are circumstances where a court might allow one parent to change the child's name without the other parent's consent.
When can a child's last name be changed without father's consent?
Courts might allow a name change without the father's consent in certain circumstances. These may include 1. Absence or neglect by the father. If the father has been absent for a significant period or neglectful in his parental responsibilities, the court may allow the change. 2. Abuse or harm. If the father has a history of violence or abuse, a name change might be allowed to protect the child and the custodial parent. 3. Change in the child's best interest. If the court determines that changing the child's name is in their best interest, it may allow the change. This is often the case when a child has no established relationship with the father. Remember, these scenarios do not guarantee that a court will allow the name change, but they are situations where the court may consider it.
What factors do courts consider?
Courts often weigh various factors when deciding whether to allow a name change. They might consider 1. The child's preference. If the child is old enough to express a reasonable preference, their opinion might be taken into account. 2. The impact on the child's relationship with both parents. Will the name change enhance or harm the child's relationship with either parent? 3. The length of time the child has used a certain surname. A court might be more likely to allow a name change if the child has not been using the father's last name for long. 4. The reasons for the proposed change. The court will also scrutinize the reasons for the change, particularly if it's motivated by an intent to alienate the child from the other parent. In conclusion, changing a child's last name without the father's consent is possible but requires a strong case demonstrating the child's best interest. It's a complex area of law, and the rules can vary based on jurisdiction. If you're considering pursuing such a name change, it's advisable to seek legal counsel to understand the local laws and processes better. Thanks for watching, and we hope this video has provided some clarity on this complex issue.